Well, I read a whole book on it called The 5 Things Every Syndicator Must Know to Stay Out of Jail. So if you want to get a copy of that, you can go to stayoutofjail.com. But I think the first one, the chapter 1, is what I kind of alluded to a little bit, is that people not, especially newbies, people not understanding that what they're doing is issuing securities.
What's up, everybody? It's Mason McDonald and Dan Haberkost here with another episode of the Big Picture Blueprint, where we got to interview an attorney that can help you stay out of jail. He's one of the biggest real estate syndication attorneys in the country, and all of the people you know and listen to on podcasts, he might be their attorney. But before we do that intro, Dan, how are you doing today?
Great, Mason. Just trying to absorb everything we just heard. There's a lot of complexity to this, and I think a lot more people are illegally raising money than we realize. So this was insightful.
Yeah, absolutely. And it's good to get validated that a lot of what we are doing is not illegal. We are operating legally with our fund, as well as a lot of the ways that we raise money. But beyond listening to me ramble about it right now, listen to this episode where we have Mauricio Rauld here. And Mauricio is the founder of Premier Law Group, the premier syndication attorney in the country that helps real estate syndicators stay out of jail. He is one of a few lawyers that actually speaks English, regularly traveling around the country, speaking to real estate syndicators about how the legal piece fits into the overall syndication puzzle. He's shared the stage with the likes of Robert Kiyosaki, Ken McElroy, Brandon Turner, and the real estate guys, and really just a fun guy to have a conversation with. Without further ado, let's bring Mauricio in.
All right. Welcome, Mauricio. How's it going today?
It's going great, man. Thanks for having me. We're looking forward to it.
Yeah, absolutely. We're excited to have you on. I know we've both heard you on the Drunk Real Estate podcast a number of times, and so it'd be fun to actually have a conversation. But we wanted to start off by asking about the word syndication, right? In the last 5 years, and especially if you're in the real estate world, in a lot of people's minds, that's become synonymous with apartment investing, but that's not really what it is. It's more just a way of raising money, pooling money legally. So can you kind of give us an overview of what a syndication actually is, what its purpose, and when it would make sense to create one in any context?
Yeah, that's a great point. I mean, syndication is just the act of pooling resources. It doesn't even have to be money. I mean, you could pool talent and credit and relationship and time. I mean, there's all kinds of things. Now, most of the time when we're dealing with securities anyway, we are pooling money or pooling capital. But to your point, you know, you could, and we do raise capital for real estate. You can raise capital for businesses. That's what a private equity group does. For them, they raise capital to buy other businesses. You could buy, crypto. You could do a crypto fund. You could do a marijuana dispensary thing, which was pretty popular a while ago. And I always joke that when one of the events I go to, they actually syndicate lunch. Like literally, they put a lunch together, right? And everybody pays into the lunch, and the speakers and the faculty need to eat for quote unquote free. So everybody pays pool the money, a little bit more money than the lunch actually costs to afford the faculty to eat for free. And so that's kind of a simple pooling of resources. But yeah, it's just that, just pooling of money to go buy whatever it is that you want to go buy, or scale whatever it is that you want to go scale.
Yep. Okay, great. Now that that's clarified, when does a syndication become necessary? If Mason and I want to just put 50 grand together, each of us, and go buy a house for 100 grand, do we need a syndication, or can we just do that as partners? Or where's the distinction where it becomes necessary?
Yeah, so syndication to me is sort of, in my world, is a little bit more vernacular. I mean, what you really need to ask is, are you issuing securities? Because if you're in the business of issuing securities to your investors or partners, now we have to worry about and comply with all the securities laws. And so the definition of a security, if you want to put it that way, like what's the definition of a syndication? The definition of a security is anytime you're taking money from passive investors where the returns are generated by your efforts, meaning you're doing all the work and the investor is simply writing you a check and going home, and you're the one that has to generate whatever return for the investor, that is a securities offering. And it doesn't matter whether you have 1 or 2 or 1,000 or whatever, then you have to at least start thinking about the securities world. And once you realize that, you either have to register that security or register that syndication with the SEC, or you have to find an exemption to registration, or it's illegal. Those are literally your 3 options. So to your point, if you're just trying to get together, the 2 of you want to get together and pool just the 2 of you, if you can structure it in such a way where the returns are not generated by one of your efforts, but is generated by both of your efforts or the group's efforts, that's where it becomes not a security and you start working into the realm of partnerships or joint ventures, for example, because the returns are not relying on the efforts of one or more people. It's relying on everyone's efforts. It's literally like you're starting a business.
So help us distinguish between whenever that's a security and how to effectively use promissory notes, whether secured or unsecured, where you go out and you get a private lender for the purpose of purchasing an investment and you're giving them a return based on just, the interest on the principal. And so I feel like a lot of people, I see it all the time of, hey, help me buy this house and I'll give you an interest rate on it. How does that kind of get differentiated?
Yeah, no, great question. And promissory notes are probably the trickiest part of them all because it's first of all, there's no clear black and white answer. It's very, very facts and circumstances. It depends on how you're doing it, what the purposes of it. But the danger of promissory notes is that they let me just backtrack a little bit. We were talking about what a security is, right? The SEC does not care how you structure that syndication or how you structure that syndicate. So you could call, like I said before, you could call it a joint venture. You could do it as a note. You can do it as a membership interest in an LLC. You could do it as a TIC agreement, a tenants in common agreement. You could do it as a profit sharing agreement, a contract, a high five, a handshake. The structure itself doesn't matter. You have to ask yourself, are you taking money from passive investors where the returns are generated by your efforts? So when people, the danger of the promissory note is that it starts to become something that's called an investment contract. An investment contract is part of that general securities definition. With promissory notes, you've got to start with the assumption that it is a security. That's kind of where you start. Now, there's ways to overcome that presumption so you kind of get it outside of the realm of securities, which I'll get to in a second. But generally speaking, if you look at the definition of a security in the statute, the first word from like a laundry list of things is note. Like a promissory note is a security. Now, the exception to that is if it's a short-term note, like a 9 months or less, and it's purely on interest, to your point, that's by definition not a security. So that's one way if you're doing, for example, if you're flipping or wholesaling or doing all the kind of really quick turnarounds where you might need money for 6 months or 3 months, right? You could structure a note where it's like, hey, it's less than 9 months. I'm paying you, a 12% interest and interest only, and it's, irregardless of what the performance of the property. That's one way to get around the promissory note. The other popular one in the real estate world is it's generally accepted that if you have a note that's secured in first position from real estate, that's also going to be rebutting the presumption that it's a security because it falls into one of these categories that the courts have said, hey, these are really not securities, even though they're promissory notes. So a note secured by real estate is generally considered not a security. Those are kind of your two black and white, as black and white as I can get. So if you come to me and say, hey, I want to do one note that's secured by real estate, it's in first position, I'm good. If you start fractionalizing the note, now you have multiple people doing a note, right? Now it starts to look like an investment contract or potentially can be viewed as an investment contract. So it gets a little bit more complicated. But notes are tough, man. It's not an easy yes and no answer when it comes to promissory notes. The one thing I will say, though, if you're trying to argue that it's not a security, definitely make sure that the return of that note is not tied to the performance of the property. So don't do a profit share. Don't do, then it starts to look more like a partnership. So just do a purely, here's a note. It's this interest rate, and I'm going to pay you this interest rate irregardless of the performance of whatever I'm using it for. Theoretically, I could go put it on black in Vegas or whatever, and I'd be fine as long as I'm paying back your principal and interest pursuant to the terms of the note.
That makes sense. What about unsecured promissory notes of saying Granny wants to, lend $100,000 at 5% interest rate that you're paying back on a monthly basis for you to get your business started?
I mean, I think that's where, you could argue if it's one person, like you said, one granny gives you one loan that's purely based on that, there's probably a decent argument that would work. But if you're now getting three of them, right, you need $300,000. So now you have three promissory notes and it's being used to buy an investment. That's where I think you cross the line into the securities, because that's how most people would view that as a securities offering.
Got it.
Yeah. Oh, okay. Do you have something you want to add there, Mason?
No. I think where, people will get held up is what the purpose of the investment is. And I think sometimes whenever it's lending, for operating capital of the business where, you log into QuickBooks and it's like you're pre-qualified for this loan right here, as a business loan versus going to use this loan to go buy a property and all sorts of stuff like that. It can get really messy really, really quickly depending on the volume of business.
Right. And don't forget, and that's those scenarios too, a lot, if you talk about credit cards or now we're talking about licensed institutions already. So they're regulated by others. So if it's another entity that's regulated, like the banking industry is being regulated by whatever the banking rules are, then that's going to be like, hey, the consumer's protected over there, so we don't have to worry so much on the security side. But if it's just like you and me or your company that starts to issue notes, you do have to think it's not automatic, like, hey, it's a promissory note and therefore it's not a security. By definition, it's a security, and we better start figuring out how do we argue that it's not. But the presumption I would start that unless it's for less than 9 months, that it is a security. That's the presumption.
Got it. Okay. Good to know. So we've established what a syndication is, what classifies something as a security versus a note versus not just a loan. Now, what are some of the mistakes that you see capital raisers making, both as newbies and the experienced ones, that are most likely to get you in trouble?
Well, I read a whole book on it called The 5 Things Every Syndicator Must Know to Stay Out of Jail. So if you want to get a copy of that, you can go to stayoutofjail.com. But I think the first one, the chapter 1, is what I kind of alluded to a little bit, is that people especially newbies, people not understanding that what they're doing is issuing securities. So we kind of alluded to that at the beginning, whether it's a promissory note, whether it's, hey, I didn't even realize it. So joint ventures is probably the biggest one of all those. People, it's funny, I get calls every so often about joint ventures, and they'll say, hey, Mauricio, it's a kind of a small raise. It's only friends and family. I think I'm going to do this one as a joint venture. That's kind of and I kind of laugh because whether something's a joint venture or a syndication, you don't get to make that decision, right? The SEC gets to make that decision. The structure is what it is, however you decided to structure it. So calling something a joint venture doesn't make it a joint venture. You have to structure it in such a way where the returns, like I said earlier, are generated by everyone's efforts. So usually less than 5 people. Everybody has sort of proportional voting rights to the ownership. Everybody's put in monies. Everybody has some expertise. Everybody's rolling up their sleeves and actually contributing to the return. If you can show that, then it's a joint venture. Unfortunately, the vast majority of quote-unquote joint ventures I see are just securities offerings that they're trying not to call it, especially if you start charging fees that start to look like a syndication, right? They're like, well, I'm going to take a carried interest at 20%, or I'm going to do a pref. All those things point to it being a syndication, because if everybody's contributing proportionally, then why would you be getting more? Why would you be getting a carried interest if you're not doing all the work, right? The whole reason a syndicator gets a carried interest, which is sort of that sweat equity, because they're doing all the work. And the whole idea is I do all the work, investors, you just give me the capital. But that's not how it works in a joint venture. So that would probably be the number one. Promissory notes are probably another great example of folks thinking, hey, I don't want to really deal with a syndication law, so let me just structure this as a note, and somehow they feel like that gets around the securities laws. And again, the examples you were giving me were very sort of vague, but the ones I see are, hey, I just need to go buy an apartment building, and instead of raising money into an LLC, I'll just get 10 people to loan me $100,000 to go buy the building. And somehow they think that because it's structured as a note or 10 different notes instead of a LLC or some LP or something, somehow that gets them around the security laws, which could not be further from the truth. I think the other big mistake people are making, I don't know if it's a mistake, I think people are sort of aware of it. I've got to believe they're aware of it because, or maybe it's just my ego that I think I've been talking about it for so long that everybody's seen it when the reality is probably very few. But all of my colleagues have been talking about this, but this idea that people can raise capital for you without some kind of a license, right? So this is something that's going on in our industry quite a bit, where especially these days, where it's getting harder and harder and harder to raise money just because the economy and, a lot of LPs are having some hard times. And so they're a little bit more hesitant. People are concerned about either already being in a recession or a recession is coming. And so it's getting harder and harder. That's a fact, to raise capital. And what's happening, and it's been happening for many, many years now, is that they're bringing, either other groups are offering, or literally they're trying to bring in people into their syndication for the sole purpose of bringing in the capital. And people forget, not that they forget, but again, it's the role of a securities attorney like myself to think through all of these things, even though it may not come up in our particular conversation. But generally speaking, you need a license to go raise money for other people, right? You need a broker-dealer license, right? And even you guys, I'll give you guys as a great example, because again, most people don't think through this, and they don't have to, because that's what the lawyer's for. But even the two of you, right? You guys are partners. You guys go out and raise money. as part of your one of 50 things you need to do is you obviously need to go raise the capital. You are actually technically, the way the SEC looks at it is you are raising capital for others. You are raising capital for your syndication or your fund in your case, right? Your fund, that's a separate legal entity. You guys are over here and you're raising money for that entity. So technically speaking, you guys are either need to have a broker-dealer license, which you don't, or you have to find an exemption. And that's where people mess up because most of us, like you guys, fall into this exemption very, very easily. But when you bring in money from the outside, that exemption starts to fall apart really, really fast. And you end up with a situation where they don't fit into the exemption and therefore they're literally raising capital without a license as an unlicensed broker-dealer.
Wow. Okay. That's a lot to digest. Listen to.
That's why I stopped, because otherwise I'll just keep going down this path of the thing. But yeah, so that's a big issue right now. These co-GPs bringing in capital where the primary role is to raise the capital. They're not doing substantial duties, which is what's required for them to actually be doing real work in the syndication. They're literally being brought in because they have access to $1 million or $2 million or $500,000, and because sponsors are having a hard time getting over the finish line, it's very enticing. If somebody can come in, if Mauricio suddenly says, "Hey guys, I know you're short $750,000. I've got a couple of investors I can call, I can bring them in, but I want 10% of the deal." Right? That is me getting compensated 10% of the deal in exchange for me bringing in money. That's broker-dealer activity, and I'm practicing without a license. Just like you can't practice law without a license, you can't practice medicine without a license, you cannot raise money for other people without a license, a broker-dealer license.
Yeah, okay. Interesting. So I really wanted to backtrack for a second. You've talked a lot about the distinction or the importance of who's putting in the effort, right? Who's doing the work. You can't be doing all the work and then your investors are passive and not be a security. But what about simple flips? Like for what Mason and I do, we don't do any work after we buy it. It's just listed. The realtors resell it. What if we're just getting capital for one of these simple land flips that we're doing where neither of us are doing anything active? It's just a realtor reselling it. How is that viewed by the SEC?
Well, I would disagree. I would disagree with the assertion that you're not doing anything. I mean, you guys are the mastermind of the operations. You have to go find your agent or whoever the team members are to effectuate this flip. I mean, you're putting in the expertise. I mean, the point would be who else is doing it? You know, if you had a third, here's where that issue would break down. If you had a third partner and your third partner was doing all the work and you guys were just funding it, that would start to look like a security because you're bringing in the capital and this third partner is doing all the work. But in this case, it's impossible for nobody to be doing work. Even if it's your real estate agent that does the bulk of it, you still had to come up with a game plan. You still have to go hire the agent. You still have to go file the tax. You still have to do all that. Somebody's doing all the work.
Sure.
So if it's not you guys, who is it, right? And if it's a team member and you're quarterbacking it, that's not what I'm talking about. Your investors, the people who are writing the check to invest in a particular deal. If they are not involved and they're relying on your efforts to go make the return, that's where the securities offering comes into play.
Got it. Let's, I think, spend a little bit more time on all these exemptions. Can you, I guess, one, define substantial duties, and then two, just start hammering out, listing out exemptions of how people get around this in a way that keeps them out of jail?
We're talking about the exemptions of the Reg D exemption, or we're talking about the broker-dealer exemptions?
Let's talk about broker-dealer exemption.
So the broker-dealers, the main exemption, there's only really one that really applies to us, and this is what's called the issuer exemption, right? It's a terrible name because it's really not the issuer. It's really for you guys, you guys are not the issuers. The issuer is the LLC. You guys are associated persons of the issuer. But basically there's a bunch of more, but the ones that are really relevant, because obviously you guys are not registered investment advisors or officially broker-dealers. But essentially the three elements are, number one, you cannot take transaction-based compensation, meaning you don't get paid based on how much money you're raising. You specifically, you guys, because you guys are all the sole operators here, you guys are getting compensated for, finding the deals, underwriting the deals, finding the market, putting the team together, asset managing, hiring the property man, like all those things that you do, raising capital being one of them, but it's one of 20 things you guys do. So that's what you guys are getting compensated for, right? You're getting compensated for all that work. You cannot get just compensated for the transaction, meaning for the amount of money that I'm bringing in, I'm going to get a percentage of that, a percentage based on how much money. So no transaction-based compensation. That is the hallmark of broker-dealer activity. Number two, you have to be doing what's called, quote unquote, substantial duties. And I'll get to that in a second, but it is a very, very nebulous term. which is causing some issues. And then the third element is that your primary role in the syndication has to be doing those substantial duties. Meaning you've got to spend more than half of your time doing the thing versus just raising the money. And when I say doing the thing, I'm talking about doing the thing after you've closed. Because a lot of these co-GPs come in is that they raise a bunch of capital, right? So they're involved in the capital raising process, haven't done any due diligence. They didn't find the deal. They're not doing any underwriting. They're not doing any of that stuff. They basically bring in the deal closes, and then they're gone. Like they're not involved in the actual asset management of that asset, right? Or that work. So you have to spend more than 50% of your time. Your primary role has to be doing the thing, like the real thing. Now, to be fair, the challenge that a lot of people are having is that substantial duties is a very, what the hell does that mean, right? And there's no clear guidance from the SEC. The SEC is really focused on the transaction-based compensation part. Like that's the clear cut for them. I think the primary is pretty easy. Again, 50% of your time or more. But what do substantial duties mean? And I think that just comes down to sort of a facts and circumstances situation, which is like, well, number one, how much of the deal do you own? Do you own 2% of the GP, or do you own 49% or 70% of the GP? The less amount that I own, I would say the less substantial duties I need to do to justify my 2%, versus if I own half of the GP and brought in all the money, I'm going to expect a lot more duties to be done. One of the things that people try and, this is one of my pet peeves actually, is when you bring in a co-GP, it really you should be bringing in a co-GP for a legitimate reason, right? Maybe you're expanding to a different market and you need somebody boots on the ground in a different market, and so you bring in a third partner, or maybe it's a different asset class that you never worked on before, so that this person's an expert in that thing. Like you really are bringing them in for a legitimate reason other than just raising money. The challenge is people are doing it reverse. They're bringing the folks in primarily to raise money and then trying to figure out, okay, how do we justify this thing so that we can make sure we fit into this exemption? What substantial duties can we give this person? And the only guidance I can give you is in that scenario is give them as much substantial duties as you can come up with. There is some anecdotal evidence which I've not been able to find. So my hunch is that this was provided by a SEC staff member at one of these webinars, it could have been a webinar, I guess, but these seminars that attorneys do where they don't officially speak for the SEC, but the question always comes along is investor relations enough, right? So that's one of the questions I get a lot. It's like, oh, this person's going to do investor relations. That's the substantial duties. And again, through the grapevine anecdotal evidence, the SEC has said that in and of itself is not enough just to be the investor relations. I will push back a little bit on that. I think it depends on the level of investor relations that you do. I'll give you a couple of extreme examples. I think if you are one of 17 investor relations people that only talk to your investors, I think that's problematic. That's probably not going to work. But on the other hand, we have a client whose investor relations person is pretty much, I don't want to say everything, but like that's the person who hired me. The investor relations person is the one who called all the syndication attorneys, vetted them all. The one that I never spoke with the principals, I spoke with the investor relations person. He hired me. He's the one who interacts with, prepares all the business plans, interacts with all the investors, prepares all the reports, figures out what the returns are that need to be done, coordinates it with the rest of the team. I mean, this guy is legitimately involved. Plus, he's a part of the company, right? So he's not like, because that's another issue too. Like if you have a person who's raising money for this syndication, this team, and then they do 7 different deals with 7 different sponsor teams, that's also kind of a red flag, right? Versus somebody who does 7 different deals with the same sponsor team. So it's all of these facts and circumstances get into play, but that's probably the trickiest part of this whole thing is that the term substantial is pretty nebulous, and you could probably argue your way out of a lot of it. I just think most of the way I've seen it, I would not buy into that they are doing substantial duties.
Okay. There's so many questions that are coming up. And this is why Dan and I believe in hiring an attorney and using our attorney to help us navigate all of these questions, where it's amazing how much attorneys will bill for responding to emails. It seems like it takes them a long time to type those responses.
And before you go, let me answer that. Let me address that real quick, because a really good securities attorneys that whoever you're using, probably 99% of the time, this wouldn't even come up because they're just running through the scenario in their head. And like, if you guys came to me and said, look, it's just the two of us, and I wouldn't even bring this up. Like it would not be an issue of whether you're an unlicensed broker or an issue exemption. That's just, I just know it's fine. It only comes up if I'm talking to you and you say, hey, I just brought in this third person. And then I'm like, okay, well, what is he doing? Oh, he's doing this. And then I'll start doing some grilling. But 99% of the time, we have like this bag of tricks in the back of our mind or all these regulations that we know, but we're only going to bring into the forefront the ones that we think is specifically applicable to your specific deal. That's the first thing. And the second thing is I hope the folks are now, these days, most attorneys will be charging a flat fee and not billing you for every single email, because that's a large law firm if it is.
It's a pretty big law group, but I know that we're paying $750 an hour for our attorney to answer our questions. But our goal is to stay out of jail, which is why we do that. So in the rise of social media, podcasts, courses, I get advertisements for courses on create your own fund, create your own syndication, all this kind of stuff. I have to imagine there's a significant amount of people that are doing things wrong or illegally. How much prosecution is the SEC doing to all these people that are syndicating, creating funds and stuff like that?
Yeah, I check. I haven't done it in a while, but I periodically will pop in there. There's a press. If you just type in SEC press release, you'll see kind of all the enforcement actions. Securities is a pretty broad category, so you'll see a lot of random prosecutions, but not that many in this particular thing. And I think the reason for that is, up until recently anyway, we haven't really had a downturn, right? Like, everything's been pretty gravy, especially since social media became a thing, right? If you think about the last major financial crisis was 2008, 2009. I mean, Facebook was around and all these social media, but they weren't to the level they are now. So you've had it up until recently, probably 13, 14, 15 years of things where things are just going great. Like, people can throw a dart at a dartboard and things are going to go great. In fact, I know for a fact that a lot of sponsors look like $1 million because they brought, not only did they meet expectations, but they crushed their pro formas. But it wasn't because of anything they did. If you look under the hood, it wasn't like they increased occupancy, increased NOI, or even pulled off their pro forma. It's just cap rates went down, and so no matter what happened, you made out like a bandit. Like that, now that's, people are starting to realize that now, because they're not getting the bailout of the cap rate compression. But I think you're gonna, to the extent you are gonna see, obviously the last couple of years, people have been losing money. You've seen it all over the news. People are losing their deals. They're going to foreclosure. So if you're gonna see any enforcement action, any claims, this is the time period you'd see it. But I have not seen any significant enforcement. In fact, I'd love to see enforcement on the substantial duties piece. I'd love to see some more, because this is a prevalent issue on bringing in co-GBs to raise capital. It'd be nice to have some guidance from the SEC as to what's acceptable, what's not, so we can use that moving forward. That would be really nice.
Got it. So to expand on Mason's question, where do you see people most often going wrong with advertising on social media and podcasts like this?
Yeah, I think that's one of the chapters in that book, talks about, using social media in your deals. And it all comes back to the exemption. That's why earlier I asked what exemption, because once as we go back to the beginning, once you understand that you're in the business of selling securities, I think we talked about it. You either have to register that security with the SEC, find an exemption to registration, or number 3, it's illegal. Those are your 3 options, right? And so we never register, because that's kind of going public. We never want to do anything illegal or non-compliant. So we're always looking for an exemption to registration. And that's where, when you hear 506B, 506C, you hear the Reg A, Reg D, those are all exemptions to registration, so that we don't have to go register, because registration takes over a year, costs 7 figures. Like, we don't have time for that nonsense. Like, I've got to close my deal in 90 days or 60, 90 days. I don't have time to wait for the SEC to get their act together. So depending on what exemption you rely on will dictate whether you can and cannot use social media at all, right? Because if you use an exemption like 506B, which is by far the most popular exemption out there, well, that prohibits general solicitation and advertising. So you would not be able to go on social media at all. And not only would you not be able to talk about, a particular deal, you clearly could not say, hey, I'm in contract to buy a 100-unit apartment building, call me, or here's a webinar I'm doing. But just like the definition of a security is really broad, the definition of of advertising or an offer is extremely broad. And it includes not only an actual offer, but it also includes something called conditioning the market. So anytime you post something on social media that gets people excited about a potential deal, that could be argued to be conditioning the market. So my recommendation generally is, if you have an active deal, if you're doing 506B specifically, if you have an active deal, I would stay off of social media, stay off of podcast. I mean, you can post about your cats and your dogs or whatever, but don't get cute. about, hey, I'm visiting this property and I'm doing due diligence and all this kind of stuff.
Wink, wink.
Because wink, wink, because people can't, I'll give you a great example of how to use that. But so I would stay off social media. And the way I would use social media if you're doing 506B is when you're in between deals, right? Because there's two instances where you can use social media, I believe, to forward your goals here. Number one, the SEC has stated, like, you can always talk about you and your company. I mean, the SEC acknowledges you have a business to run. And so if you're talking about your credentials or you're talking about what's going on in your businesses, my favorite posts on that are updates to your properties. Hey, here's a before and after picture of the pool. Hey, we bought this dilapidated property and look at the crappy pool. We just finished renovating it and look at the beautiful pictures. Or maybe even the units. Hey, we just renovated the kitchen, or like that those kind of content is great. But so that's one thing you can always do. And that's a little boring. Let's face it, talking about you and your resume or whatever. But the way I would do it is if you're in between deal, there's nothing wrong that prevents you from talking about value add content, right? So nothing wrong with posting about why real estate, if that's your niche, why real estate's the greatest asset class in the world, or why this particular market is the best market, or why this is your investment thesis, or being a thought leader. That's probably a great way to do it. Just get on these social media platforms and just show your expertise and your opinions about the market and the economy and all that. There's nothing wrong with that. And if you can then somehow get their email or take them off of social media and you can start having conversations with them and start to get to know them a little bit, then when you do have a deal in the future, you may be in a position to offer them because you've gone through the vetting process, so to speak. You've figured out if the investor is suitable for your investments, they're sophisticated, and you can get to the point where you have what's called a substantial relationship with your investors. And once you have a substantial relationship with your potential investor, then you can offer them deals under 506B, because the assumption is if you have a pre-existing substantive relationship, then by definition, you did not generally solicit or advertise that new deal. So that's how I would use social media if you're doing 506B deals. If you're doing 506C deals, which is the other exemption that's the most popular, then you are allowed to advertise. So in those cases, you can go on social media and say, hey, I got a 100-unit apartment building. I'm doing a webinar tomorrow, or just wire me a check tomorrow. You can do all that stuff because of the exemption you're using. That's why it's so critical to meet with your attorney early on in the process so you guys can figure out what exemption are we going to use, because based on the exemption will dictate what you cannot do leading up to the deal and during the deal. And advertising is probably the biggest one there. Can I advertise? Can I not advertise? Can I take accredited investors, or is it not accredited investors? Those are questions you want to answer early so you can figure out this is the exemption I'm going to use, and now I got to follow the set of rules of that particular exemption.
Awesome. No, I think that makes a lot of sense. And I think if there's any themes to this show, it's one, go to stayoutajail.com, because that's I love that you have that domain. There's probably so many people. I'd be interested in the traffic of how it. They're like, what the frick is this book? I got arrested for drunk driving, and I'm on my phone right now. How do I stay out of jail? But and to hire an attorney and talk to an attorney about this, it's worth the money on the front end to do it right the first time. And with Dan and I, that's how we have our fund set up of Reg D, 506C, evergreen fund, so we can solicit, advertise, all that good stuff. But I think probably one or two more questions kind of on the syndicator, fund manager, sponsor, principal side of things, and then we'll probably switch a little bit to what to look out for if you're the LP or the investor. But Mauricio, with fund managers, and it's a two-part question, so take it how you want. What aspects of them do you see, or what character traits, or what do you notice about the fund managers that are really, really successful in this business? And then on the second part of that, what structure of funds or investment vehicles are they using that you see are more successful? Like, do you see more success with people using a 506C versus a 506B? And then on the actual manager side.
Well, let me ask the second question first, because I think once you get into the realm of a fund, which is what you guys are doing, where you're actually raising, again, there's so many ways to structure them, but in general terms, a fund would be somewhere where you actually raise the capital first and then go looking for a deal. Those generally require larger sums of money, which generally requires you to go outside your friends and family. So most funds, true real estate funds, I would say are 506Cs, so that they have the ability to actually go market and raise this thing. Because most funds are going to be, in the tens of millions of dollars, right? Especially in multifamily, like you can't even, if you want to buy 3 or 4 you're not going to raise $1 million or $2 million. You're going to raise 5, 10, 15, 20 at a minimum. So in order to do that, unless you have a ridiculously high, investor base or whatever, most of them I would say are 506Cs. When you're doing project-specific deals and you're just starting out, I see a lot more 506B deals. But we almost, I'm trying to think if we currently have even a Reg A. 95% of all exemptions are either 506B and 506Cs. And that's certainly our experience. And the newer you are, inevitably you want to bring in a non-accredited investor because your Uncle Bob or Aunt Karen's not accredited. So as you start your career, you usually start project-specific and start doing 506Bs. At some point, you run out of your friends and family and people so you switch over to 506Cs, and then eventually you get tired of doing one deal at a time and having to stress and raise money for each individual deal. You kind of graduate to a fund, and by then you're already kind of doing a 506C. So I would say that. And then in terms of what qualities, one of the things I've been talking a lot about, because I'm seeing this not so much for a general fund manager, but this fund of funds thing that's popping up, or these feeder funds, which drive me crazy. I'm even surprised I'm even saying this, but it's so true. Like the really good syndicators are folks that are really good at what they do already. They're masters at operating, whether it's multifamily, whether it's self-storage, whether it's mobile home parks, whatever asset class it is, they're a master at it. And they need more capital to sort of scale that, to grow. Like, I'm really good at it, but if I could just do this 10 times bigger, we'd all make 10 times more money. I bring in my friends and family. Versus others have no clue what they're doing, and they're just starting out, and they just came back from a course, and they're just starting out, and they're just really good at raising money. And the goal of raising money isn't just to raise money. The goal of raising money is because you're trying to scale a business. Like, you already have a business. This happens to be the real estate business, the one that I'm involved. But whatever your business is, you're really good at this business. You want to scale it, and the only limiting factor you have is the capital. That's why you go out and raise capital. Too many people right now are in this, because I think a lot of people are teaching this. They're basically teaching you how to raise money, and that's the skill in and of itself, is the raising the capital, and they don't have the experience to go do the stuff that they're supposed to be doing with the capital.
No, I think that's great, and it's something that Dan and I talk about a lot of, whatever colloquialism that you want to use of walk before you run, don't put the cart before the horse. And I think, you'll hear it often, especially if you're at any of these conferences or a local meetup or something, where people are like, hey, how should I, focus on my asset protection by using a foreign irrevocable trust owned by, this, by that, by this. And it's like, well, how many rental properties do you own? It's like, oh, I don't own any. It's like, well, fucking go find a rental property first. Do it in your name, and, it's fine. But, which, don't listen to me for any advice about anything. But I think something that I've kind of encountered in this world is it's really easy to go raise a few $100,000, $1 million or something like that. You get, 10 investors at 50,000, 100,000. It's decently easy to raise 25 million to 50 million. It's that kind of in-between rate that gets a little more complex. And one of the best things that Dan and I enjoy about having guests like you on the show is to get advice, where a fear that we've had is raising too much money, because it is, the idea of, we might not have all the deals lined up or something like that. And we don't want to start making mistakes by rushing decisions and investing into deals that are, not good deals, because we have the need to deploy capital so quickly, because, we don't want it just sitting there. How do you kind of help on the legal side of making sure that fund managers aren't raising more money than deals than they have whenever it is kind of that REIT or blind pool type fund?
Yeah, that's definitely a concern with a fund, because like you said, you've got the money, and what if you can't place it? Now it's not working for you. And then if you've got the fund structured in such a way that you're paying some kind of preferred return, and that preferred's ticking while you're not earning anything. So that's one issue. The other issue is the sort of the incentive for you to put it to work, even though it may not be in the best interest of the business or your investors, because you're trying to get acquisition fees, or you just, hey, I need to keep the lights on, so let me just acquire stuff for the fees. I think the way that most of my clients will handle that is through a sort of a cash call mechanism, where instead of taking all the capital up front and starting that process going, they'll just take a percentage. So like, let's say I commit to $100,000 or 250 or whatever level you're at, then maybe I only collect 10% of that up front. So that only 10% is sitting in my bank account. More than anything, it's just going to have a hook so they don't change their mind later, even though you've got legal docs. You're probably not going to go after somebody for $100,000 if they change their mind. And then once you find the asset, then you could cash call the rest. At that point, it's really quick. The documents already say, hey, look, when we find a deal and we need the money, we're going to cash call the money. You need to get the money in within 5 days or a week or whatever you say. And if you don't, you're going to forfeit that 10% you already gave me. So it really gives them a hook so that they don't get the, investors have this shiny penny syndrome all the time. So that'll kind of anchor them in. So that's one way we've been doing it, especially like a couple of years ago where literally if you had the money in your bank account, you were earning 0% interest. Now it's got a little bit better because at least you could put in a money market account or you could do some cash management where you're at least generating maybe 5%. But that's probably the best advice I would do because then that eliminates a lot of these incentives for you just to like, if the money's literally burning a hole in your pocket, because it literally is, especially if you're giving somebody a preferred return, it is literally costing you money every single month. And that gives you the wrong incentive to place the money. And even though you have a legal obligation to act in the best interest of your investors, there's just an incentive that's going in not aligned with your investors at that point.
I gotcha. Yeah, no, I think that makes a lot of sense. And I think that, to ask another question and explain it to me like I'm four. So the method whenever we raise money is, we've got our operating agreement, subscription packet, and blah, 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 all that stuff. We send it out to the investor that's given us the commit. How does that work okay, the investor wants to give us 100,000, our minimum requirement for an investment is 50,000, with different, years of commitment based on Class A or Class B shares and legal jargon, blah, blah, blah. How do you actually structure that okay, we're going to take 10,000 of your 100,000 right now, and then we're going to do a capital call or a cash call or whatever it is, for the other 90,000 whenever we're ready for it. How does that tangibly work? Like what documents?
Yeah, so that'll be language that we put in both the PPM itself, which is the disclosure document, because I'm disclosing to you that's what we're doing, especially the part about forfeiting, because that's the key. So that has to be very clearly delineated in the PPM, the disclosure documents. And then from a mechanical standpoint, you also wanted the operating agreement, but it's just literally it's language in the PPM. I mean, it literally says, your commitment's going to be $100,000. We're going to take 10% first, and we're going to hold that in an interest-bearing account. And then then we're going to sponsor upon finding a deal within 7 business days of finding the deals. We'll give you notice, and you've got 7 business days to do that. And if you don't, we'll forfeit. It's literally just laid out from a language standpoint in the PPM. It's not necessarily a specific structure. It's just similar to, honestly, it's almost like it's separate from the main cash call provision, because every operating agreement will have sort of an additional capital contribution provision in there that outlines what will happen if you need more capital for whatever reason. So there's usually sort of a waterfall of step 1 is going to be this, and I'm going to give you notice, and then you're going to have this much day to give it to me. And if you don't, you're going to get diluted. There's only a step-by-step process on a regular cash call, which a lot of people are paying attention to these days because there's a lot of cash calls going on. But so this is a separate section that kind of outlines, again, all the steps that we just described. And it just, what I think we do really well at Premier Law Group is we write even the documents. I mean, one of the best compliments I always get is that I have this ability to turn complex legal matters and make them easy to understand. I like to think that our documents are the same way. If you look at the way our documents are laid out, it just flows. It's almost like if you're not a syndicator, you can kind of follow the structure of the PPM. And so it'll just have a section on there that literally a section with a heading just specific to this sort of initial capital contribution and how that's going to work. And we're not going to take 100% of your capital at the time of subscription. And sometimes it gets even a little bit with a fund, for example, especially a larger size, you may do multiple cash calls. So then I got to think through the language of each level, because what happens, so usually it's you put in 10% of the deal. And then once we need the money, we'll give you notice. We'll provide you with a 7-day notice or a 14-day notice for you to give us the additional 90%. And then if you don't give it to you, you'll be out of the deal and you'll forfeit the 10%. But sometimes I may not need the rest of the money. I only may need half of the money. So what happens if they put in half of the money this time and then don't give us the second half? Do they forfeit the entire 50% or just the 10? I mean, all of that has to be literally spelled out paragraph by paragraph, sentence by sentence. And I try and make it just as easy to understand, like any layman can read it and just, okay, I got it. Step 1, step 2, step 3. And so, but that's just a disclosure, and it's in the documents in a particular heading.
Got it. Makes sense. And I think that's where, your legal team is a team member with you whenever you're doing this, of you're making it so where, the people that you're working for, the fund managers, are able to go out and explain to their investors, hey, these are all the situations. And you've already got the questions that a lot of investors or LPs might have answered through the documents, and make it easy to explain. One last question on, I guess, the manager side is RIA. We've had friends in the space tell us to, get the fund registered as, I guess, an RIA, registered investment advisor. We didn't do it. We didn't think it was necessary, I guess, for this first one. Can you talk a little bit about RIAs and what to look for, whether you're on the fund manager side or on the LP side whenever investing?
Yeah, so this is an interesting topic because it usually doesn't come up, but recently it has. And so one of the, I'm starting to call this sort of a quadrant, because there's really 4 separate regulatory statutes that we have to go through. But for real estate, we really focus primarily on one, which is the Securities Act, the Reg D, the 506B, 506C. But there's a bunch of others that don't apply when you're investing in real estate, but does apply when you're investing in securities. And so if you guys are putting together a real estate fund where you're raising capital of the fund and then you're acquiring properties, then I would not worry about investment advisory rules whatsoever, because investment advisory rules only applies to the investment in securities. You guys are investing in real estate. However, if you're putting together a private equity fund where you're buying shares in somebody else's business or buying businesses outright, or if you're doing a fund of funds where you're investing in other people's syndications, well, you're just buying shares in their company. Now you're in the business of acquiring securities, and now I do have to pay attention to the investment advisory rules. And the way it generally works is that if you're under a high threshold, I don't know how big your fund is, but if you're under $150 million in assets under management, which most of my clients are, then you're not even allowed to register at the federal level. You're looking at the state level. And so every single state has their own different rules and exemptions, right? Do I have to register as an investment advisor in my state, or is there an exemption? Most states, not all, but the vast majority of states have some sort of an exemption. It just depends on whether you like the exemption or you can fit into the exemption. So I'll give you a good example. What state are you guys in?
Colorado, and our fund is registered in Delaware.
Yeah, well, it doesn't matter where it's registered. So I don't know off the top of my head where it's called, but Colorado is going to have an investment advisory exemption. Like it's going to be, if you follow these things, then you do not have to register. But sometimes people don't like that. So I'll give you a great example. The state of Florida couldn't care less about being an investment advisory as long as you don't have more than 15 funds. Right? You have one, maybe you have a second one or a third, but you have less than 15. So as long as you don't have more than 15 funds and you don't hold yourself out to be an investment advisor, you don't have to register in Florida. Same thing with Pennsylvania. But then there's other states like Texas, which is actually fairly simple as well. You don't have to register in Texas, but you have to limit your investors to accredited investors only. And you have to file a little truncated ADV form. So if you're trying to do a 506B, right, and you want to take some non-accredited investors and you happen to be in Texas, that's going to be a problem for you because you won't fit into the exemption. And then there's states like Massachusetts and California where you are exempt, but then you have to limit your investors to qualified purchasers, right? People who have more than $2 million in net worth. So it just depends. And then if you're in Hawaii, they don't have an exemption. So you have to register. So it really depends on your particular state. Off the top of my head, I don't remember what Colorado is, but there's several websites that you can go to. And I'm happy to, if you want to, I can probably send it to you too, where it'll just kind of give you a summary of all 50 states. And that's where I would start. I'd be looking at Colorado and seeing what the exemption is. But again, it only applies if you're investing in securities. So basically you have a private equity firm, because if you're investing directly into properties, even if they're through LLCs, but they're properties that you're buying, you're operating, then you're not in the business of investing in securities. You're in the business of investing in real estate.
Makes sense. Okay, so we need to hit on the LP side of things a little bit, working with all these different syndicators. What advice would you give to someone that wants to be a passive LP when they're screening syndicators, when they're looking for someone to place money with?
Yeah, well, as an LP investor, I'll tell you the number one thing I focus is on the sponsor team itself. Like, to me, that is the 99% of my focus is going to be on the sponsor team, right? The due diligence on the sponsor, like what is their expertise? What is their track record? Well, how many years of experience? Not only in general, but that particular asset class, right? Like if this is a multifamily deal, like how long have they been doing multifamily? Is this are they really self-storage guys that this is their first multifamily? That's going to be like, okay, now I want to make sure there's somebody on the team that knows about multifamily. So are they experiencing that particular marketplace? You may have been in Texas or Colorado or whatever for all these years, and now you decided to venture out to Florida. I'm like, well, what do you know about Florida? What's your team look like in Florida? How well do you know that market? And it doesn't mean that if you don't have that expertise, I'm out. It just means that somebody on your team, I'd like to see somebody on your team that has that level of expertise. And so that's where it really goes down. And then these days, there's so many sponsors, again, going back to this co-GP model, where sometimes there might be 7 or 8 or 9 or 10 people on the sponsor team. I want to know whoever I'm talking to, are they going to be around once I give you my money? Like, I know I can trust you as an individual. I talk to you. I'm comfortable with you. I'll write the check. And then are you going to be actively managing the asset, or is there somebody else in the team that's going to be actively managing the asset? And what is the credential of that person? So I always start with the sponsor team as my number one thing. And once I get comfortable interviewing them, hopefully meeting them in person, going down and checking out their operation. Do they have a team? That's another question I want to know. Is it a one-man show or do they have a team? And so that's another question I like to ask. I also like to ask, is this their full-time gig, or is this sort of a side hustle for now? Do you have a W-2 job and you're just starting out? Honestly, I don't like to invest with folks that are just starting out. I mean, you can make your mistakes with somebody else's money. I want to know people who have a team, have been doing this for a while, and this is their full-time thing. So to me, that's where it starts. And then the next level down, I would then go into the obviously the particular asset class and the market, because I mean, I might like multifamily, and this happens to be a mobile home park thing, and I don't like mobile home parks, or maybe it's a self-storage deal or whatever. I mean, the different asset classes go through different cycles, so I want to make sure that we're aligned on the asset class and also the market. You might be invested in a market that either I don't know anything about, or I just think, hey, your deal's in Florida or something. I'm like, I don't like Florida right now, or I haven't liked Florida for a while now. So the alignment's sort of the next thing. And then the last thing, which is important, but it's like the most interchangeable part, is the actual, details of the investment itself. And one thing that I pay a lot of attention to that I think a lot of newbies forget is I don't focus so much on the returns themselves. I focus on the risk-adjusted returns, because a lot of people will take two different deals and, well, this one pays me 15% and this pays me 13%. Why would I go with the 13%? I'm going to go with the 15%. And they don't realize, well, there's a risk adjustment to that. Is this more conservative? Is it more aggressive? Are my assumptions crazier? And then obviously I'll go all the way down to looking at their assumptions, assuming it's a project specific. Obviously with a fund, I don't get to see the specific deal itself. I just look at your fund criteria and have to. With a fund, it's even more important. I mean, you're literally betting on the fund manager at that point. Like, you don't even know what they're going to buy. But on a project specific deal, I'm going to look at their assumptions. I'm going to determine for myself whether they're aggressive. They'll say, hey, I'm going to raise rents by 10% a year for the next 10 years. I'm like, okay, that's crazy. I don't agree with that. What I like about it is I can then readjust the pro forma for my assumptions. Like, your assumption might be, I'm exaggerating 10%, but your assumption might be, I'm going to raise rents for 3% for the next 5 years. And I might be like, that's a little aggressive. I think you might be able to get 2% the year one, but the rest of the years, I'm going to assume it's a zero rent growth or whatever. And then I can still, at that point, I can determine whether I still like the deal or not. Same thing with occupancy. Like, hey, it's at 60% occupied. I'm going to get it to 95% in 2 years. I'm like, well, do I agree with that assumption? Do I not agree with that assumption? Do I adjust the assumption? So that's kind of my pecking order. I start with the team. And like I said, if I was going to allocate weight to it, I would probably say 95% of my weight goes towards the team first. And the good news is, once you do all that due diligence on the front end and you feel comfortable with a particular operator, then you don't have to do the same work again the second time. Like, you've already done that work. Now I'm really focused on the next deal. I'll see if it's something that matches my risk tolerance and my goals.
Yeah, that's consistent with what we're hearing across the board, that the operator is almost everything. So start with that. So on the flip side of that, you alluded to a few answers to this, but more black and white, I want to ask, what are some things that you see that in your mind are huge red flags that would cause you to never invest with someone as an LP? Something that, hey, if you see this, run.
If I don't see a PPM when one's required, that's a big red flag. In fact, in the old days, I don't do these anymore, but I would, when you start a firm, you do whatever puts food on the table. So I would review PPMs for LPs. LPs would say, hey, I'm thinking about investing in this deal. Can you look at the document, whatever? So I'd spend a couple hours talking to the client or the client, and then looking at the PPMs. And you'd be surprised. A lot of times there is no PPM. And so the question is, well, why isn't there a PPM? It's like, oh, they told me that one wasn't required or something. And then you just realize they're just cutting corners because there's a non-accredited investor. Clearly a PPM is required. I saw one deal where all they had was a business plan, but it wasn't even a business plan. It was almost like a sample business plan. It was really crazy. It was like a sample business plan, educational only or something like. It was just something crazy. And so those are kind of extreme examples. The other thing I would really pay attention to is making sure that the PPM and the operating agreement align, because sometimes there'll be something that's in the PPM. If it's not in the operating agreement, that's really the document that really does govern. So that's another thing I would pay attention to in terms of a red flag. But to me, it's again, I just go back to the sponsor. It's like, I want to do the due diligence on the sponsors. To me, red flags would be if I'm talking to either referrals or people I know, did they not do what they said they were going to do? Did their reporting, did they communication? How were they communicating? Especially if things weren't going well, did they stick their head in the sand, or did they over communicate or keep communicating? I was just at an event last week. One of my big clients said, I'm investing literally in 2 deals. And he said, I'm probably going to lose both deals. It's like $100,000 each. But in one of the deals, the sponsor has stuck their head in the sand. Like, they won't respond at all. Maybe if I text them, they'll respond. I'm like, yeah, because you're a big influencer, they'll probably respond. But everybody else they're not responding to. And then the other group, they've actually doubled their communication. They're communicating consistently, and we know exactly. It's not good news, but it's their communication. And he said, look, I will never invest with the guy that stuck their head in the sand. But for this guy, I probably would give him another investment or another chance, because again, it doesn't mean it's your fault that the deal hasn't gone well. We've gone through some challenging times, but sticking your head in the sand is never the answer. And so if that was something, so I think to me, the real red flags will just go, have they gone into foreclosure before? Have they lost a deal before? Have they, those are the things that I'm going to be focused on. And I think, and not just me, I think that's what LP should be focused on in general.
Yeah. And it goes back to businesses about relationships. There's so many deals out there. There's always going to be more deals out there. They're sometimes hard to find, sometimes not hard to find. But if you're working with the right people and can operate in good faith, I think you're going to have more success both as a sponsor and as an LP.
One of the tips I would give, if you don't mind, one of the tips I would give LPs that they haven't been paying attention to this at all. Now it's becoming an issue. So people are focused on it, but just reporting, right? The communication's a big thing right now. LPs in general are pissed. They're pissed because they're losing money, but also because they're not getting communicated with. But one of the things is reporting. Like, one of the things I would ask for is a sample report from the business, because sometimes people get their reports and they don't like them, or they think they suck, or it's very, very vague and not common. But they never ask for a sample of that report, prior to investing. So if you're thinking about investing, there's no reason why the sponsor can't give you a prior report. They can obviously redact anything that they feel is confidential, but that way you'll know this is kind of their standard operating agreement. Their standard operating procedures. And like, one of the things I like to see is actuals versus pro forma, for example. Like, here's the pro forma. I know we're not always going to hit the pro forma. Pro forma is basically something that's made up, and so I'm not expecting to hit it all the time. But I'd like to see sort of a quarter by quarter analysis. Hey, year one, we expected that you were going to get an 8% pref and a little bit more. We're a little short on that. We got you 7%, so you got all the money. And so I just want to see that comparison of what you promised versus what you're actually delivering. And that's all part of the reporting, so you want to get a sample of that.
Yeah, absolutely. And I think that right there, it's basic. And there's a lot of complexities with all of this, but if you can just verify that the sponsors are going to do what they're saying they're going to do, you're going to have a better time both on the LP side and then potentially co-GP side and everything like that as well. With there being, and we want to be respectful of time, so we'll wrap this up here really quickly. Last question though, with the SEC, and there's a lot of regulation involved in what we're talking about, how often are the laws changing in this space? Is it something that it feels like it's changing all the time and adapting with the modern era, or is it kind of staying the same? And how do the GPs, stay abreast of all the knowledge that is, or, legal changes that are happening?
That's a good question. It goes in waves. Like I felt, not felt, if you look up, first of all, if there's something new, I talk about it. There'll be content on my YouTube channel or something about it, or I'll put it on the social media platforms. But I felt like maybe right before the change in administration, there was just a flurry of updates. Like there was that are relevant to our specific space. Remember, again, securities is extremely broad, so there could be all these regulations and stuff, but it doesn't really apply. But I mean, fund managers had a huge update early on this year that then quickly got revoked. It lasted like 5 months and it got challenged and it got revoked about all these side letters and stuff for fund managers that didn't apply to most of my clients because they were all, again, in real estate. This is really for security stuff. But 3 or 4 years ago, there was a huge overhaul in integration laws that allowed people, for example, now to start a deal under a 506B and then finish it up in a 506C under the same deal and pivot. That's a big one. The accredited investor definition is constantly changing. In fact, the SEC has a mandate to do a review every 4 years. They just did one at the end of last year. I think that's going to be changing. They had introduced, right before the change in administration, a huge change that was a proposed change, which would allow people to actually get transaction-based compensation, something we talked about earlier, because there is a gap in the marketplace because they're telling us we need to go use licensed brokers, but licensed brokers don't want to talk to you unless you're raising $50 million. And so what about the little guy here in the middle that's raising 2 or 3 or 4 million? How do they get capital? So they introduced a sweeping new thing, which is going to be amazing, where you could literally get paid transaction-based for making introductions, for referring people. A proposed rule came out, and then with the change in administration, that kind of died. So I do think that with the change of administrations, you tend to see a little bit more changes because there's a change in philosophy and a change of thought. And so I think that'll happen again this time, depending on who ends up. Remember, whoever wins the White House gets to appoint the head of whatever department you're looking at. So there's a Securities and Exchange Commission. Right now it's Gary Gensler. He's got different thoughts than the prior commissioner. And if you've got a change in administration, we have a new SEC commissioner, then they're going to have their own thoughts. And either, my guess is a lot of the proposed rules that didn't pass, that didn't get to final, will probably get revisited and probably opened up for a comment period again. And a lot of those will pass, including the one that I think everybody's waiting for, which actually, this one actually technically passed. They just didn't implement it. And that is allowing people to become accredited investors based on some kind of an exam and not just based on financial stuff. So there was actually a rule that passed the SEC 3 years ago now that said, hey, if you take a test under a qualified, somebody who's qualified to and has license to administer this exam, and you study and you pass for this test, you will become accredited. It's one way to become accredited. The problem is they never certified any company to give the exam. So there was a stalemate there, and it just has been sitting there for the last 3.5 years. So I think a lot will happen if there's a change. If it's the same administration, then basically I think the chance of changing are less. But they're constantly changing. It just depends on whether they're specific to our target little niche, which is such a small sliver of the law, which is what we do, which is on the Reg D and the sort of the Securities Act, specifically really Reg D. You guys are using 506C. Most of my clients will use either 506C or 506B. And that's where accredited investor comes into play, and a lot of these other, raising capital stuff as well.
Yeah, that's fascinating to hear the changes in the laws that may be happening, might not be happening, and how quickly things can change based on the administration. Because there are gaps in the market, and it goes back to what we said of it's really easy to go raise $25 million. It's really easy to go raise a few $100,000, but it's that in between stage where the more opportunity for legal capital connection will come into play. Well, we just hit an hour, and we truly appreciate all the time that you've given us today and all the advice that you've given our audience and ourselves. Mauricio, where can people find out more about you?
I've got two spaces. Number one, well, if you want the ebook, 5 Things Every Syndicator Must Know to Stay Out of Jail, just go to stayoutofjail.com. I also have a YouTube channel, Mauricio Rauld, which I think I've got over 400 videos. I think I've hit pretty much every topic you can think of. And if you want to get a hold of me directly, you can just go to askmauricio.com. That'll connect you to the little consultation form, and feel free to reach out to me and just mention that you saw us here on this podcast.
Fantastic. We truly appreciate it. This was really fun, really insightful. And everyone, this is Mason McDonald and Dan Haberkas with the Big Picture Blueprint, signing off.